Hello friends, in the series on the income tax cases, today we will discuss a very important issue on Form 67. Form 67 is filed for claiming the foreign tax credit which is available to the assessee, and Rule 128 says that this Form 67 should be filed up to the date of filing the return of income by the assessee under section 139. The moot question in the present case arises that whether this requirement of filing Form 67 up to the date of filing the return of income is directory in nature or mandatory in nature, or if the assessee files the form before the assessment, whether it is under section 143 subsection 1 or 143 subsection 3, whether the assessee will get the benefit of Form 67. This issue has been taken by Madras High Court in the case of Duraiswamy, KUMARASWAMY versus Principal Commissioner of Income Tax and others, and this case has been reported in 460 ITR at page number 615, and the date of the judgment is 6th October 2023, and the matter has been decided by Honorable Madras High Court. In the present case, the assessment year relates to the assessment year 2019-20. In the present case, the assessee filed the return of income but somehow escaped to file the Form 67. When the assessee realized its mistake, the assessee filed the Form 67 suo motu on 2nd February 2021 along with the tax deducted at source certificate. When the assessee filed this form, after that, the intimation under section 143 subsection 1 was issued on 26th March 2021, meaning thereby that the intimation was issued after the Form 67 has been filed by the assessee. This was the important fact of this case. But when the intimation was issued, the assessee was not given the benefit of that and the demand was created. The assessee requested CPC through letters 27th March 2021, 3rd May 2021, 26th May 2021, but all the requests were rejected by the CPC. So the assessee chooses in this case to file the revision petition under section 264 before the Principal Commissioner of Income Tax. When the Principal Commissioner of Income Tax heard this revision application, he was also of the opinion that Form 128, Rule 128 is mandatory in nature, and if the assessee has not filed Form 67 before the date of filing the return of income, the benefit of foreign tax credit should not be allowed to the assessee. The assessee was not having option other than moving to the writ court. The pleading of the assessee in regard to his writ petition was that Form 67 is filed before intimation under section 143 subsection 1. The department has accepted Form 67, has not rejected Form 67. The assessee relied the Supreme Court judgment in the case of CIT versus GM Knitting Industries Private Limited, which was reported in 376 ITR at page number 456, in which there was an issue regarding the filing of the Form 3AA, and the court in that case said that filing of the Form 3AA, if the form is filed during the assessment proceedings and after that the assessment order is passed, even then the requirement of filing the form will be deemed as fulfilled. The assessee also relied the judgment of the Bombay High Court in the case of CIT versus Shivanand Electronics, which has been reported in 209 ITR at page number 263. So in both these cases, there was a clear message from the courts that if the forms are filed before the assessment, then they are the sufficient compliance of the law. When the Madras High Court heard the writ petition, Madras High Court was of the opinion that Rule 128 is directory in nature. The Madras High Court said that the rule is for the implementation of the Act and are always directory in nature. So the Form 67 filed by the assessee is the due compliance of the law, and the benefit of foreign tax credit should be given to the assessee. Friends, this case is important, although there is a circular of the department which also holds good in favor of the assessee, which says that if the Form 67 is filed up to the end of the relevant assessment year, even then the benefit of Form 67 should be given to the assessee. But this case takes away the assessee on a position which is far much better and says that if the form is uploaded before the order under section 143 subsection 1 is issued to the assessee, even then in that case it will be a sufficient compliance of law. At the end of this video, once again I am repeating the name of the case. The name of the case is Duraiswamy, KUMARASWAMY versus Principal Commissioner of Income Tax, and this case has been reported in 460 ITR at page number 615. The matter has been decided by Madras High Court and the date of the judgment is 6th October 2023. Thank you, friends.